Appeal in the matter of Yieldpoint Stable Value Fund LP and Kimura Commodity Trade Finance Fund Limited.
Good morning, my lord.
To be the wrong way round. It's the way we normally see.
We set up the wrong way round.
It doesn't matter.
I hope you're
It's just slightly discombobulating.
I'm the appellant. I appear for the appellant, rather.
Yes.
Kimura with my learned friend Mr. Searle. And my learned friend Mr. Pilbrow, King's Counsel, appears with Miss Carrington for the respondent.
Yes.
Yieldpoint. The appeal concerns, as you will know, an issue of interpretation of a contract which the deputy judge, learned deputy judge, Mr. Houseman, King's Counsel, identified in his judgment as the MTV participation. The issue at trial and on this appeal is whether this contract involved Yieldpoint's participation in the true sense, which I'll come to shortly, in a secured loan facility to an entity known as MTV, or merely, as my learned friend put it at trial on behalf of his client, in effect a short-term unsecured loan to Kimura, repayable after a year, albeit with some, I would suggest many features of a participation. In other words, the hybrid that the learned judge identified in his judgment. Now, the judge decided that issue in Yieldpoint's favour, and he did so following a one-day commercial court trial under the shorter trial scheme that took place on the 18th of May. He handed down his draft, produced a draft judgment the next day, the 19th of May, and handed down judgment on the 22nd of May, and we'll look at the judgment in due course. There are, in a sense, two orders that the judge made. The substantive trial order, which, just for your note, is a core bundle, tab 4, page 63, whereby the judge ordered Kimura to pay Yieldpoint the principal sum with which the MTV participation was concerned, $5 million US. And in addition, there was then a cost judgment on the 20th of June, which was essentially concerned with the issue of whether a Part 36 offer could be taken into account in terms of costs. The learned judge held that it could not be, essentially on the basis that it was pitched at 99% of the $5 million paid, and was therefore not a genuine offer to settle the proceedings. And it's interesting to note that in that context, the judge, his reasoning for that was that he considered the issue was very much up for grabs, as he put it in his cost judgment, until the very end of the case. And your lordship and my ladies will have seen that in the judgment, the main judgment, there are a number of references to the difficulties with both sides' cases and the discomfort that the judge felt in relation to the interpretation that he ended up reaching. And those are gathered together in our skeleton argument at paragraph 7, but I'll come to some of them in due course.
Well, the main difficulty for your construction, the judge regarded it, was the 12-month maturity.
Yes.
And what happens on 12 months?
Yes, indeed. What does it mean by when you say you have a maturity date of the participation of 12 months' time? And as I'll come to just to sort of give you an idea of where I'm coming from on this, ultimately the judge started from the proposition that meant it was a loan, and therefore the maturity date of the loan was the 31st of March 2022, and therefore because it was a loan, it was repayable on that date, and therefore one has to interpret the rest of the agreement in that way. And we'll come to it, but it's very clear that there's a point in his judgment where he pivots from pointing out all the issues that really are favourable to my client when one looks at the MPA, to a conclusion, well, but if it's a loan and it has to be repaid, then those difficulties are not insuperable and they have to be overcome. And
I think, to be fair to the judge, I think what he asked is what could that mean?
Yes.
If it was a participation?
Yes.
And your answer to that was there'd have to be a valuation.
Well, I'm going to come to the valuation point because that's obviously very important. But the prior point really is, what it means is that the money is on risk during that period. Yes. It's a capital risk. Yes. And if that is to mean anything at all, it must mean that if there is a default during that year period, then that risk is on Yieldpoint, because otherwise it's meaningless. And the consequence of that is that in the event that there is a default, and there was, it's common ground, then that amount, if it's truly to be on risk, can't simply be repayable by Kimura. Some other mechanism, some other explanation must be provided. And I'll come to explain it. It works a bit better to explain it to you in the context of seeing the contract itself.
Yes.
Now, by its notice of appeal, my client seeks to set aside both, obviously, the main judgment order and the costs order. Since Kimura has made payment in full, that will involve the amount being repaid, ultimately, if the appeal succeeds. What I wanted to just do before I get to the contract itself is just to, very briefly, some initial background, which I'm sure you will have picked up from reading anyway, but just in case. Kimura, the appellant, my client, together with an entity in the Anglo-American group, AAML, was a senior lender under a loan facility known as the MTV facility. And MTV stands for the name of the borrower, Minera Tres Valles S.P.A., a Chilean company engaged in the mining of high-grade copper ore and copper cathode production, essentially for the use in, among other things, batteries. Each senior lender, AAML and Kimura, had provided $22.5 million to MTV under the facility, which was entered into in December 2019, restated, amended in November 2020, and was due to expire, absent default by MTV, at the end of December 2024. And the facility agreement and the connected intercreditor agreement are in the supplemental bundle, starting in tab 13 at page 124. And I'll come back briefly to one of those shortly. The MTV facility was secured, as one would expect, against the assets and output of MTV. There was a facility and a security agent, Citicorp, and the intercreditor agreement provided for the way in which the security would work in a conventional way in a loan of this sort. And one sees that the intercreditor agreement is at page 320 behind tab 13. And that's relevant in our case when one comes back to look at what is meant by the recourse rights, a concept that's captured in the MPA and incorporated into the slip, the offer and acceptance document that records the contract in our case. Yieldpoint, the respondent, is and was not a party to the MTV facility. It described itself in evidence before the judge at trial as an asset management firm. It's founded in 2020, which targets short duration credit opportunities within the commodities market. I'll just give you the reference for that. It's Polachek 1. Mr. Polachek was Yieldpoint's witness at trial, paragraph 6, supplemental bundle 1, tab 7, page 48. What Mr. Polachek says there is that Yieldpoint doesn't take direct commodity price risk. It targets an index stable return for investors. And in his second statement, paragraph 11, supplemental bundle 1, tab 9, page 78, he identified what that return was in this case. He says the base interest rate on this deal was only approximately 7.5%, and therefore the price participation element was critical in getting us up to the returns, as he put it, we needed, i.e. above 10%. So Yieldpoint's return on this transaction over a year was pitched at that level, about 10%. When one comes to look at the income payments that one got, they got on the amount.
I thought it was LIBOR plus 7.5% plus
was
participation in the profits.
It was. That's how one gets to that figure. LIBOR at the time was below 1% in the days of lower interest rates. The LIBOR plus 7.5% gets you up to about 7.6, and then the price participation was key to the copper price, and that got the return up to, as Mr. Polachek said, around 10%. Now, pursuant to the, I should say this, on the 19th of February 2021, Kimura and Yieldpoint entered into a contract with each other known as the Master Participation Agreement for Trade Transactions, the MPA, which we'll look at shortly. Pursuant to the MPA, the parties have entered into only two contracts. The first was on the 22nd of February, so shortly after the MPA was entered into. Kimura and Yieldpoint entered into a transaction relating to sunflower seeds as a small transaction worth $3 million over a 90-day period. The underlying borrower repaid the amounts due in that case. There was no default, and that's referred to in the evidence. I'll just give you the references. In Kimura's evidence, Mr. Manuel, paragraph 31, supplemental bundle 1, tab 8, page 60.
Can I just ask you, do we have a transcript?
Of today? I don't know that. Let me just check. I don't think so is the answer, looking behind. But if it would be helpful to get a transcript from the recording, of course that could be done.
Yes. Well, it really depends on how carefully you have to note down all your references.
Well, I'd like you to note them down carefully, obviously, but if I'm quite happy to undertake to ensure that we get a transcript to you, if that would be
Yes, okay.
I mean, there are obviously quite a lot of references along the way, but once we get to the contracts, actually it's just looking at the documents themselves, and it might be helpful just to go through them in hard copy.
Yes.
I was going to give you Mr. Polacek on the other side's reference for the first transaction. Polacek 1, paragraph 8, supplemental bundle 1, tab 7, page 48. That was the first of the contracts. And then on the 30th of March, the contract that we're concerned with, 2021, the parties entered into under the MPA, the MTV participation, and that's the focus of the appeal. They then, of course, there was then a year of that transaction being in play. They then fell out with each other, and they haven't, as I understand it, entered into any other contracts since then. Now, the judge interpreted the MTV participation, agreeing with Yieldpoint to involve, so far as concerns their $5 million investment, a loan by Yieldpoint to Kimura that required Kimura to repay the money, come what may, on the 31st of March 2022. And by come what may, I mean irrespective of what had happened in the meantime in relation to the MTV facility. On that interpretation, the judge held that Yieldpoint had not put any of its capital at risk of default by MTV. Yieldpoint's case was and is that it was exposed only to the risk that Kimura might not repay the money on the 31st of March 2022. Kimura's case at trial, which the judge rejected, was that its contract with Yieldpoint was a proper sub-participation agreement, pursuant to which Yieldpoint had made a capital risk investment for 1 year, which could be renewed and extended, but the investment was by way of pari passu and proportionate participation with Kimura as a co-venturer in Kimura's share of the MTV facility. And on that interpretation, having invested its capital, the capital was at risk if MTV were to default during the 1 year period prior to the maturity date of the investment. If, on the other hand, MTV did not default prior to the maturity date and Yieldpoint had not renewed, as it had the right to do at its option, its investment, the investment would have to be refinanced by Kimura and Yieldpoint repaid because the participation would come to an end. If, on the other hand, Yieldpoint renewed, as it might have done, and as it sought to make provision for, as we'll see in the contract itself, then its capital would remain on risk. There would be a new offer and acceptance. And in return for that, Yieldpoint would continue to receive the substantial income payments that were due under the original deal. There is, as I've said to you, no dispute that in the event MTV defaulted, and it did that in the year period of the contract, so towards the end of 2021, it suspended its operations in January 2022, and the position subsequently worsened. It was declared bankrupt by the Civil Court of Santiago in Chile in February 2023.
So can I just understand that a bit better? There was a forbearance initially, wasn't there?
There was.
As I understand it, there was a true default on the 31st of March.
By the 31st of March. By the 31st of
Okay,
March.
I'm not sure we're told when the forbearance.
No, I'm not sure. Well, I think we can probably get it from the judgment. But there are, in addition, some of the documents going backwards and forwards between the parties, my lady, in the period towards the end of 2021. In the judgment itself, no, Judge, it's tab 5 of the core, page 74. You can see towards the bottom of the page, paragraph 48, the deal ran smoothly until late 2021. Kimura remitted interest payments and price participations between the 27th of March and the 31st of December, but nothing after that date. The troubles manifested in November 2021, resulting in suspension of operations in January 2022. And there's the reference to the forbearance that my lady referred to, paragraph 49. And then the reference to the renewal, paragraph 50, and then a default on its capital repayment and interest instalment due on the 31st of March, and it's paid nothing since that date. But I think the position is, I think I can say to my lady that the position is that interest was not paid in the preceding months.
And those were defaults.
And those were defaults as well.
Thank you.
As I said, there are documents towards the back of the bundle that contemporaneously record the position in relation to that, which I can give you references to.
If it assists, a description of the forbearance is in the press release, which one has it behind tab 29, supplemental bundle 2, volume 1, tab 29, page 688.
Thank you.
It is the official press release describing it at the time.
Can I then?
Only what the judge said at paragraph 49. Granted a forbearance to MTV in November 21 in respect to the capital instalment due on the 31st of March. 2. So how then did it default on its capital repayment on the 31st of March?
Just defaulted on the interest.
Yeah.
Just defaulted on the interest due in between. It doesn't say there that there was a forbearance in respect of interest.
He says at 51 they defaulted on the capital.
It's a funny expression to use.
There are, as I said, some of the contemporaneous documents give a little bit more detail. If one looks in the supplemental bundle 2, tab 35. You can see there an email in January 2022 which is from Kimura. Sorry, which is from Kimura to Yieldpoint. We need to bring to your attention, towards the bottom of page 706, that we've been informed by MTV management that there is a default scenario that's currently being investigated. This is owing to MTV having to shut down production. And it refers then to the effect on the company's cash flow. And you can see that we're expecting this today, still around potentially pushing out 2022 repayments to any unsecured restructured creditors. I think what I can say to my lord and my ladies is that it is common ground that the facility was in default in the sense meant in the MPA definition of default before the 31st of March 2022.
Well, it's not in dispute.
It's not in dispute.
No, that's important.
It's not in dispute.
Okay, and as I understand it, under the main facility, that would have entitled acceleration
It would. It would.
of the whole facility.
Of the whole facility. And we can look at it, but the facility is, I think I'm right in saying, is in the terms that one would expect of a facility of this kind. It contains all the rights that a secured lender would normally have in that situation. For present purposes, the relevance of that is really in how that interacts with the position of obviously Kimura, but also Yieldpoint under the MPA, which I'm going to come to.
When was the facility accelerated?
That I'm going to have to.
It never was. But, if it assists, the terms of the forbearance itself are set out on 688, and where they explain the undertaking given by the senior lenders, which they have agreed not to accelerate or enforce their rights or remedies under the facility agreement should MTV fail to make scheduled loan repayments on March 31st, June 30th, or September the 30th, 2022.
Yeah, I understand those to be referenced to repayments of principal.
Indeed.
not interest.
Indeed, Molly. So there is a bifurcation. There's a distinction. We're not going to insist on the repayment of capital, but it is right that they failed to pay interest payments.
Yeah.
The small interest payments separately.
And by this stage, they had actually suspended operations at the mines. I think it was.
By November, that's November when the announcement is made.
Yeah.
Suspension is then a number
During
of
the
months
12
later.
months.
I can give you one additional reference that just anchors
Thank
into the
you.
documents, if I may. Tab 39, page 719. 25th of February 2022, Kimura wrote to Yieldpoint, and you can see on page 719, paragraph 3, we confirm that as previously advised to you, MTV, and you can see, continues to be subject to a judicial reorganisation effective in September 2020, has been and continues to face cash flow problems due to the halting of arrangement, halting of operations, and then C, has failed to pay its price participation payments under the loan facility for each of December 21 and January 2022. And then it says a default has occurred as we've received no amounts from MTV to pass through to you as participant. And you can see at the top of page 720 that Kimura has informed MTV of their failures to perform. And you can see then a reference to continuing to consult with Yieldpoint in good faith to reach agreement as to what steps to take to obtain payment from MTV. So that's, hopefully that gives you a bit more substantial. I'm grateful to my own friend for his references as well.
I may be being slow, but how did the facility ultimately come to an end? Was it because of the bankruptcy?
It went bankrupt.
And that was
2023.
But normally those are events of default. Normally you have to actually bring the facility to an end in some way.
Well, the facility was due to expire at the end of 2024.
Yes.
But the position is that the company was declared bankrupt in February 2023, and therefore there is a claim in the liquidation, as I understand it, in Chile, in respect of the amounts that are due. And obviously that's a secured claim, but it's not one that's been settled.
But then the amounts were due depend on whether it's been accelerated.
Yes, I'm sure that's right.
There must have been an acceleration then.
Not that I'm aware of, but my own friend doesn't think there was either.
Not my lord, in anything I have seen or we saw at the trial, I follow your lordship's logic. You would have thought there must have been at some stage in order to prove the full debt in the liquidation. Yes. But I'm not so far as Yieldpoint is aware, and Kimura might know.
There's not evidence before the court. There wasn't evidence at trial about that, as far as I'm aware. We can perhaps have a further look.
It doesn't matter for present purposes. It's just the sort of story seems slightly incomplete. But it might.
Yeah, well, we'll see if we can complete the story. But the position is, therefore, it's common ground. It's in default. It's in default before the March deadline or maturity date of the participation.
Yes.
And it's in default because they failed to pay interest and participation payments before that date.
Yeah.
Now, I was going to look next at the MPA itself. And in my submission, that is the right starting point for the court's analysis of this case. And it's the umbrella agreement, which we'll find in the supplemental bundle 1, behind tab 5. The reason it's the right starting point of my submission is that it's really impossible to interpret the 2 or 3 page offer and acceptance that's filled in by the parties and agreed at the end of March 2021 without first understanding the umbrella agreement. And
well, it's not. I don't have. The judge went into some detail about this. I don't have any difficulties with this because the crucial offer and acceptance expressly refers to the master participation agreement and says that unless indicated otherwise, definitions in the master agreement apply.
Quite.
So they have to be read together.
they absolutely do. Yeah, and in a sense, the burden of my submission to my lord and my ladies is that that's the right approach. The difficulty ultimately in the judge's analysis is that he interprets the words maturity date of the participation in a way that really takes out so much of the MPA material that it's difficult to understand how that can be consistent really with the approach that my lord has just indicated. In other words, that everything is in unless expressly overridden or modified. One doesn't find anything in the offer and acceptance that says, by the way, none of these provisions are applicable from the MPA.
Yeah.
The words maturity date of the participation are put into an enormous amount of work, I'll put it that way.
Well, even though it refers to the participation,
Well, yes.
not the loan, it could have said maturity of the loan.
Yes,
I mean, I think on Mr. Pilborough's case, this could have been a 2-paragraph agreement.
well, and it's a point we make
We'll
too.
make you a loan at the following interest rate.
Yes, I mean, to be fair to my learned friend, you could label something a participation, but if it had all the features of a loan, then I suppose it would be a loan, because ultimately one looks at the substance rather than the form of it. But that's, in a sense, that's just one of many reasons why it's a participation, the label that's used, but it's perhaps not the most important in the scheme of things.
No.
I hesitate to say anything, but I'm afraid I have been looking at all the references you've given me, and my bundles do not correspond with the references. They're all over the place.
And what has possibly happened, my lady, is that there was at one stage a longer version of the bundle that had a very large duplicate document in it that was removed, and that is very frustrating.
It is, because I've been working off the bundles that I've had, and it's not your fault, Mr. Valentin, but you've now just given me 2 references and they have no correspondence, and I've been scrabbling through the bundle to try and find them.
Well, I'm very sorry for that.
So, have you any idea where I might find the MPA now?
Yes.
Well, I think in my version, it's actually tab 1 of.
It is. It's tab 1, page 5 of the very
Volume
first
one,
supplemental
there are
bundle.
2 bundles of each volume.
I know.
It is.
Tab 1, tab 5.
Tab 1 of, I perhaps gave you the wrong reference, tab 1, page 5.
Tab 1, page 5.
Volume 1, volume 1. That's tab 1.
Yes, I found it. Thank you so much. I'm very grateful.
I do have to say, I did find having 2 volumes of each volume, and particularly when you have numbering written in quite small type on the back, makes life very difficult finding, because you have to search for the volume, then you have to search for the volume of the volume.
I apologise. All I can say is I totally understand.
What council have done is taken out the back and turned it around. Yes, is that or yes, exactly. Yeah.
Well, we are where we are. I apologise for the inconvenience of that. What I can say, though, by way of reassurance, is that for the rest of my submissions, we're really going to focus on the MPA,
Yeah.
tab 1, the offer and acceptance, that's tab 3, and perhaps in between the transaction overview, which is accepted as part of the context, which is tab 2. So we shouldn't venture too much further than that.
Well, I'm relieved. Thank you, Mr. Houseman.
Now, as the judge, I'm grateful, my lady, as the judge correctly recorded, the central role of the MPA was common ground, and that's in the judgment. I'll give you the reference. It's judgment, paragraph 6. So that's in the core bundle, tab 5, page 67, where the judge said it's common ground that the MTV participation is or was a participation agreement, in inverted commas, in respect of a, quotes, participated transaction, unquotes, as defined in or contemplated by the terms of the MPA. And the judge also said it involved sub-participation of some kind or to some extent, together with equitable assignments of relevant recourse rights. So the judge accepted and recorded as common ground, as of course it had to be, that the MTV participation was an agreement that had been entered into under the umbrella of the MPA and embodied, included, adopted many of its terms, indeed all of its terms, I would suggest. Now, if one looks at the MPA itself, I'm just going to take you through briefly the points that I highlight from it. The first is, one can see the parties are Yieldpoint and Kimura. They're described as the master parties on page 7.
Yes.
And then the recitals make clear what the parties are seeking to do in the MPA. They intend that if one party offers, in accordance with clause 3, this is recital A, to the other master party, a participation on a funded or unfunded basis in respect of a capital T transaction, and that other master party accepts the offer in accordance with clause 4, then the terms of this agreement shall apply to that participation. So from the very outset of the MPA, what one finds is an explanation that this is going to, if you enter into an agreement under this MPA, you're doing it pursuant to clauses 3 and 4, and the terms of the MPA will apply to that agreement. Of course, one finds that, as my Lord Justice Phillips has identified, in the offer and acceptance document itself. Recital C.
Before we'll just leave that recital, it's worth noting, isn't it, that it recognises that a participation may be funded or unfunded.
Yes.
And it seems to me that an unfunded participation couldn't possibly be a loan.
No, because no money passes.
So you're not passing any money.
Exactly. No, and we're of course dealing with a funded participation, which one gets to in a moment under clause 5 of the 5.2, I think, of the MPA.
Yes.
But of course, my Lord is right about that. The contemplation recital B is that any party, this is in relation to affiliates, should be free to conclude participation agreements pursuant to this agreement by making or accepting an offer that expressly indicates it's made pursuant or subject to this agreement. So the concept is always that if you enter into a participation agreement, it will be one that is expressed as being subject to the MPA. And then at C, for good measure, each participation agreement concluded will incorporate by reference the applicable terms of this agreement as at the date of that participation, unless the parties expressly agree otherwise. I emphasize those words. And then the master party or its affiliate offering the participation will be called the seller. Kimura is the seller in our case, and the other party taking the participation is the participant. That's Yieldpoint.
Sorry, I think the expressly agree otherwise just governs the last
Later
right.
amendments.
words. That later amendment.
You're quite right. Unless the parties expressly agree otherwise, any subsequent amendment to the agreement will not apply to that participation agreement. I apologise, that's quite right. While we're on that point, can I just ask you to look forward to page 12, clause 1.2.5. if there's a conflict between the terms of this agreement and the terms of a participation agreement, then for the purposes of that participation agreement only, the terms of that participation agreement, as set out in the offer and acceptance or otherwise, will prevail. And therefore one has to have a conflict between the terms of the MPA and the participation agreement for that clause to kick in.
That clause only takes you so far because it's always open to the parties to a fresh agreement to say we're not going to be bound by the terms of the master agreement and this agreement will prevail. And then because it's the second in time, you assume that there's a variation of that clause.
There is that, certainly. And there is, in addition, though, the point that, and one gets it when one gets to clause 3 of the MPA, page 13, that any agreement that you enter into has to be substantially in the form specified in Appendix 1, clause 3.1. In other words, if one were to depart so radically from the scheme that's one finds in the appendix, one wouldn't be in the context of an offer under clause 3.1. And indeed, the acceptance has to be substantially in the form as well, clause 4.1. Now, transactions, one sees dealt with in clause 2. This identifies the sort of the following types of transaction that the parties may enter into by way of unfunded or funded participations. And the one that seems most relevant to what we're dealing with is 2.1.12 at the top of page 13, loans for trade-related purposes entered into by the seller as lender. Then offer and acceptance, clause 3, if a seller wishes to offer the participant a participation in a transaction. So there again, another example of seeing the concept of offering a participation in a transaction. It sends an offer in accordance with clause 20, it's the service provision, and substantially in the form, as I've said, specified in Appendix 1. And then acceptance, one sees at 4.1. You receive the offer, and it, again, substantially in the form set out in Appendix 1, accepted. Funded participation is the next concept to take it. Clause 5.2, page 14. This clause applies to each funded participation. The participant undertakes to pay the seller on the start date of the participation agreement the settlement amount without further demand from the seller. And the settlement amount is defined on page 10 as, for a funded participation, the settlement amount, if any, is specified in the offer, and we'll see that's $5 million US, being an amount equal to the participation percentage of the amount that has been or is to be advanced or paid out by the seller under the participated transaction on or before the start date of the participation agreement. And the important next step in the analysis of the contract is to look at what a participation percentage is, because the settlement amount is an amount equal to the participation percentage. That is defined on the bottom of page 9 as meaning for a participated transaction at any time the proportion that the participation amount bears to the credit amount expressed as a percentage figure at that time. And credit amount, and then goes back to page 8, means the aggregate principal amount of the seller's exposure to the recourse parties under that transaction from time to time, being as at that date of its participation agreement the amount specified as such in the offer. So the participation amount is defined by reference to the overall, and the participation percentage is defined by reference to the overall amount, the overall aggregate principal amount, I emphasize, of the seller's exposure to the recourse parties. And the recourse parties here are MTV. That's the party, singular in fact, the party to whom Kimura has recourse under the MTV facility and the intercreditor agreement. And
Is
as
the
was-
effect of these provisions that any participation pursuant to this arrangement will be at par?
Yes. Rather than the whole.
Well, we're talking about a credit default arrangement where this loan facility has been on foot for some time,
Yes.
and so you could value the credit of the borrower in the same way that when it's being suggested one might have to value the credit of the borrower on the maturity date. But the parties here have agreed, as I read these provisions, I think it's the point the lady makes as well, at par.
That it's 5 million of 22.5 million.
Yes.
And therefore that
And they pay 5 million.
and they
To
pay
get
5
their 5
million.
million.
They pay 5 million, and therefore the exposure is defined, or the investment is defined by reference to the capital amount invested or advanced, rather.
At par.
At par.
Yeah.
At
Yes.
par.
That's the effect of this agreement. It leads to a figure of par, but it's also obviously what the parties commercially agreed.
Indeed. It demonstrates that the focus is on selling down a fixed amount of the capital amount that had been advanced by Kimura to MTV
At par.
at par.
Because you could sell it down at a discount
Certainly.
or a premium.
You could, absolutely. But what they agreed was to sell it down
At par.
at par.
Yeah.
And what they were selling, what was being sold, was the rights that would attach to that capital investment
Yes.
by way of security.
Yeah.
And one can see that in a moment in clause 5.
But why isn't this quite important for you? Because can't one take from this that what then happens at the maturity date is that it's sold at par or bought back at par,
Absent default.
absent default.
Absent default. That's
And that solves your what happens at maturity date point, doesn't it?
well, yes, it does. I suppose that I'll get to it a little bit later, but there is essentially a number of options at the point where one gets to the maturity date, depending on what has happened. If there hasn't been a default and there hasn't been a renewal, then it's a par. The amount has to be refinanced because Yieldpoint is no longer takes the risk.
Yeah.
Or in order to pay it back, and it may be that at that
They
point,
participated for a year and now they get their money back on the same basis they paid it in.
the risk's been sold down for a year. They've got the income payments from that, and now the risk is back on Kimura. On the other hand, if they renew, then it goes forward. They get more income
let's
payments.
not worry about
But-
renewal.
but to clarify, if there hadn't, I mean, it wouldn't harm your case, would it, to say that if there hasn't been a default, any refinancing, in other words, if it isn't renewed, would be at par.
No, it doesn't harm my case in relation to that. We have to deal with the situation where what happens in relation to the scenario of a default, What
But
happens?
it's common ground, we've established there has been a default.
which is our situation, therefore. What happens then? And the answer is, well, the choice is between, notwithstanding the fact that the amount was on risk at a point when the risk eventuated, as Yieldpoint says, it still gets all its money back, keeps all its income payments, essentially hasn't taken any risk at all. It's got all the money back. That's their approach. The alternative approach is, well, in that situation, Yieldpoint has a choice. It can, because it took the risk, can wait and see whether MTV's liquidator pays out money that ultimately will then pass through to it through the MPA. It'll be paid out that way. Or it could sell the rights it has, or sell the value of this defaulted participation to Kimura or to a third party. But inevitably that will be at a lower value than 5 million because it's not worth 5 million anymore. But there isn't any obligation to do that on the part of Yieldpoint. It can wait and see if it wishes to do that. It could renew and it could sell whatever value is left in this participation to a third party, although I'm not It's not clear who would wish to buy it, but perhaps one would find in the secondary market a party interested in it. Those are the options ultimately. When we get to the valuation point, is one wouldn't expect to find in the contract a valuation mechanism to deal with that situation. I'll explain why in due course. But I take the point my lord makes that it's at par investment. Now, the other provisions that apply to a funded participation importantly include clauses 5.4 to 5.6 on page 15. And these, in my submission, provide a guide or a clear guide to what the nature of the agreement was the parties were entering into. And I should say that this, just before we look at them, that Yieldpoint's case and the judge's analysis ultimately assumes that these provisions only relate to income. They don't relate to capital. That's the way Yieldpoint proposes and the judge accepted. One has to read these provisions in order to deal with the situation that the capital is not at risk. 5.4, the seller agrees irrevocably that in relation to each participation, with effect from the receipt by the seller of the participation payment, the seller hereby transfers, sells and conveys to the participant an undivided 100% beneficial ownership interest in the related recourse rights associated with the payment. And then one has to go back and look at what related recourse rights means, and that one finds on page 10. It's in relation to any payment that is referable to an amount that the recourse parties are liable or are expressed to be liable to pay the seller under the participated transaction. The participated transaction is the MTV facility. And you can see that it's all rights, title, benefits, and interests of the seller arising under or in connection with the transaction documents. A broader definition as one could expect, including all monies owing to the seller in respect of principal income payments or otherwise. So the definition of related recourse rights makes it absolutely clear that the security transfer that happens by virtue of 5.4 relates not simply to income, but relates to the whole package. And there isn't any suggestion anywhere in the MPA that the parties can just opt out of those provisions. Indeed, clause 5.5 makes clear that the clause 5.4 ownership transfer, as it's described, takes place by way of equitable assignment or in such ways to give effect to clause 5.4 automatically on receipt by the seller of the relevant participation payment without the need for any further action. And then in 5.6, it's agreed, the parties agree that each ownership transfer effected pursuant to clause 5.4 is intended to put to and shall place the beneficial ownership interest in the related recourse rights so transferred beyond the reach of the seller's creditors. So it's intended to protect Yieldpoint against the situation that Kimura becomes insolvent during the period when the recourse rights have been transferred. And there is then some claim on them by a creditor of Kimura. The short point really is that none of this is consistent with there being a loan, an unsecured loan. It doesn't make any sense in those contexts.
Isn't there also an issue that if this was construed in the context of the MTV participation as the recourse rights referred to with only those in relation to income, doesn't that set up a conflict between the recourse rights of the principal lender and the sub-participant?
It does, absolutely, because if one goes back to the intercreditor agreement, you can see that ultimately the rights that you have which are transferred are in respect of everything, whereas the interpretation that the judge gives to this clause is much more limited.
But it blows the whole thing apart, doesn't it? Because the the sub-participants will be looking to enforce the security specifically in relation to income. And how does that arise? Is it pari passu, or is it?
Well, it doesn't work at all. I mean, the answer that ultimately emerged in relation to this, as I understand it at trial, and I think it's still adopted on appeal, is that just because you've got rights doesn't mean you have to exercise them. And Yieldpoint has said, well, we won't. It would be inequitable for us to exercise these rights in that situation. But that, in a sense, isn't an answer. That's not a construction answer to the problem. That's in this case, a practical solution.
Well, the question we're looking at the moment is, does one read this suite of documents as producing a participation in the broader sense, or is it only a loan?
Yes. Yeah. It's all ultimately a question of how one interprets the words maturity date of the participation, because that's really all the case hangs on.
Yeah.
And just to look at this point, what has to be said is that by adopting those words in the offer and acceptance, the parties essentially did agree, that therefore the security aspect of it is income only. But that's an enormous leap from those words. And what it isn't in any sense is an express.
Well, it goes
modification.
further than pure security, isn't it? It's saying as to capital, the lender is relying only on the creditworthiness of what's defined as the seller.
Yes.
So that if the seller, if Kimura went bust within the 12 months, then Yieldpoint would be left high and dry as regards its capital.
Yes, whereas they're not, because the whole point of 5.4 to 5.6 is that they have pari passu participation alongside.
But it's a remarkably different commercial deal.
Completely different, absolutely. And the question ultimately of interpretation, which we'll get to shortly, is if you start from the proposition that this was, you get paid back come what may, whether there's a default or not, on the 31st of March, how do you reconcile that? If that is the agreement, why would you enter into it in these terms? That's, I suppose, one way around looking at it. The other way around looking at it is, in order to understand what maturity date of the participation means, those words mean, you have to look at the words in the context of the overall contractual scheme. And the overall contractual scheme is one in which the parties agreed that all of the MPA provisions are part of this, unless expressly modified or overridden. And there isn't any express modification or overriding of them. Ultimately, what this comes down to is looking at what the parties said to each other before they signed the contract, and picking out of that an agreement that it's an unsecured loan, or that you get the money back come what may. Of course, we say that's inadmissible. But in any event, if one looks at it, it doesn't really get them as far as they need to get, because just saying it's a fixed term investment, which is really the point that's relied on, doesn't tell you that you get repaid.
No, but it may tell you that you're at risk for
Exactly.
12 months.
Exactly, and indeed that's what we say it means. Because it can't mean anything else, given the parties have adopted all the MPA provisions, including the security provision. Default, clause 6, page 15, deals with the position where there is a default that is continuing, and default, just for your note, is defined on page 8, and as we've established, that's common ground that default, the definition is satisfied. In the situation where you have a default, clause 6.2 says that the seller may take or refrain from taking any steps the seller sees fit in recovering all sums due to the seller from the recourse parties. There's then a series of provisions, 6.3 to 6.5, that involve the seller consulting in good faith with the participant as to the steps that should be taken. The participant agreeing to reimburse. I don't think that matters for present purposes, but 6.5, if agreement cannot be reached in accordance with clause 6.3 as to what steps, if any, are to be taken, either party may request elevation in accordance with clause 9.1. And elevation is defined, before we look at 9.1 on page 8, as a full legal transfer to the participant of the transferred rights. And again, we say, how is that capable of being reconciled with an income only interpretation? If there is a right to elevation, or an option for elevation that the participant takes, what it gets by doing that is a full legal transfer of rights, and the transferred rights, which I've looked at this definition yet, is defined on page 11, top of the page, third definition, as all the related recourse rights relating to that participation that have been transferred by the seller to the participant. So again, it all comes back to 5.4. What you get in the context of an elevation is not just an equitable interest, but a full legal transfer. In other words,
Just putting it into practical terms, MTV goes bust. Kimura has rights of recourse against them, participate in a winding up or whatever.
Yes.
There's a provision in here which basically says you chat about that amongst yourselves and decide what's going to happen. Kimura says they're not worth the powder and shot, we're not going to chase after them. The other party says, well, I think they might be. There's then a deal between them whereby the rights that Kimura's got are transferred over, and they then take over those rights and pursue them.
Yes.
That's effectively how it works in practical terms.
It is, and the point that I suppose I add for my part is that that can't just be income only, that has to be everything in that situation.
Yeah.
I mean, not least because in that situation, the capital amount that is much larger than the income payment. So why would Yieldpoint not want all of those rights? Indeed, that's what they've bargained for in that situation.
But I don't think there's much doubt about what the MPA means. The question, more difficult question, is to what extent it survives
Yes.
the offer and acceptance.
Yes, and I will get to that very shortly. I quite understand.
I'm not hurrying you.
No, absolutely right. That is the question.
But emphasising that in this context, I think, isn't quite the question. Because I don't think there can be too much doubt about that.
No, well, the reason I emphasise it is because when one looks at the judge's judgment, what one finds are, in my submission, quite unsatisfactory answers to the point that is made that, well, look, if the MPA provisions apply to this deal, as they do because they've not been overridden expressly, how does it work? And that's why I'm emphasising these points now. But of course, when one gets to the offer, one has to work out how much weight the words maturity date of the participation can bear.
Yeah, I suppose from the judge's point of view, once he's decided that what's happened, what the respondent is entitled to is a repayment of capital on the maturity date, all of these provisions rather recede into the background, don't they?
Yeah, well, you're anticipating the point that I was going to make when you get to the judgment, but let's just look at the point at which that pivot happens. It's in the core bundle and behind tab 5. And the relevant paragraphs are at page 77 and paragraph 60. One goes back to 76. You can see at paragraph 62, the judge says each side's analysis has its own problems. And then between paragraph 63 and 66, he identifies the problems with Yieldpoint's analysis, which are really focused on all of the points that I've been making and sort of additional ones that I haven't got to yet. They're not small difficulties, they are surmountable, paragraph 67. And what you then see is, I'll come back to it, but an explanation that is essentially it's income only, paragraph 68. He accepts that that is, subparagraph D of paragraph 68 requires radical editing, And then paragraph 69, this is really the key paragraph. These power problems are therefore surmountable, but were they or must they be? In my judgment, and not without some discomfort, I'm satisfied that they were and had to be in order to give effect to what the parties agreed for this particular deal. This was always proposed as a fixed term deal. And then he goes on, then he refers, I'm going to come back to the point about essentially the things that were said to the parties between themselves before the contract was entered into. And by reference, the concepts of assurance and expectation, paragraph 71. And then you see at paragraph 72, in this immediate context. In other words, in light of what one looks at from the pre-contractual position, the inclusion of maturity date for the participation, together with the conditions, is sufficiently strong and clear to depart from the preordained sub-participation structure. The concept of maturity date is alien to sub-participation. That's, in a sense, that's the point that helps me rather than Yieldpoint. It's apt for a fixed term loan where the lender takes the default risk, but not that of anybody else. Hence the absence of such a term or component in the template offer. Now, the reason that that's the wrong approach in my submission is that if you start from the proposition that the parties between themselves have said, before you get to the contract, it's a loan that'll be repayable. Aside from the fact that you're taking into account material that I submit is inadmissible on the construction of a commercial contract, you're assuming what you're trying to prove. If you assume it's a loan, when you get to the words maturity date of the participation, you're going to look at those as, when is the loan repayable? The loan is repayable because it's a loan. Whereas the right approach is to say, well, what do the words maturity date of the participation mean in the context of the contractual scheme? And start from a neutral position. Are they a loan or are they a true participation? Leaving out of account whatever the parties may have said to each other back and forth beforehand. In any event, leaving aside whether it's inadmissible or not, there isn't anything in the nature of a fixed term investment that necessarily connotes a loan. And saying you will be paid back is also neutral in my submission. Again, we're in the territory of inadmissible material because the question is, are you dealing with the situation where there's a default or not in that circumstance? Are you saying you'll be paid back come what may? Or are you saying you'll be paid back at a year if there isn't a default? It's neutral in my submissions to that. But in any event, all of that material is inadmissible. The judge starts from the proposition it's a loan, and therefore he reads maturity date as the repayment date. That's the wrong approach in my submission.
The judge does say something, doesn't he, about why he takes into account the background.
Yes, he does.
What do you say it's unrealistic not to?
It's back in the section dealing with the negotiations. Which starts at page 70, paragraph 28, and then goes through the back and forth, including the transaction overview, which I think both parties accept as admissible material. And then at paragraph 37, he says, the overview and the first offer dovetail on material points. They go hand in hand and will profit on that basis. I'm satisfied that both documents are admissible for the purposes of determining the proper meaning of the MTV participation. So there he's dealing with the first offer. That's just the way in which the offer is put forward initially. But then you can see that he then refers to paragraph 38 to the discussions the parties had at the end of March and before the contract was entered into. And he does the same thing again at paragraph 41. And there are other references which I'll come back to, but
Was there an issue about the admissibility of that material?
there was yes, there was. Yes. If I may, just to complete the references from the MPA.
Yes.
We have to do that. Income payments, clause 7, on page 15. To the extent the participant will not receive such payments as pass-through payment under clause 8.1, and subject to the participant complying with its obligations, the seller undertakes to pay the participant the income payment set out in the offer for the period from the start date, that's the start date of the participation, until the earlier of the final due date, the date the participation agreement is terminated, or the date the participated transaction is terminated, in each case adjusted. Now, the significance of that is it shows that it's within the contemplation of the parties that there might be a situation in which the participation ends earlier than the participated transaction. So in other words, that you have a short-term participation for a fixed term. And it provides for that situation in relation to income payments. What's the significance of that? The significance of it is that the judge in his judgment makes quite a lot of the fact that the MPA doesn't contemplate that there will ever be a participation that ends earlier than the participated transaction. And you can see references to that in the judgment. For example, at paragraph 72 on page 78, last sentence, hence the absence of a component in the template offer or any provision in the MPA for a participation agreement which ends prior to the end of the transaction, participated transaction. And there are other references in the agreement as well, in the contract, sorry, in the judgment as well. It's common ground between my learned friend and I that clause 7 applies to this contract.
Sorry, which reference in the judgment was that? I'm slightly behind.
Sorry, paragraph 72.
72.
72, last sentence on page 78. And you can see that that's a significant factor in the learned judge's mind, because paragraph 73 says the consequences of such temporal disconnect are fundamental to the proper interpretation and characterization of the participation. So he uses the fact that, or his observation that the MPA doesn't contemplate anything other than a participation agreement and a participated transact agreement ending on the same date as the reason why, the sort of lead into the fair market value point. Because you don't have a fair market, you don't need a fair market value mechanism, because the MPA is only going to be used in circumstances where the participation ends when the participated transaction ends. In other words, in our case, December 2024. And the simple point I'm making is when one looks at clause 7.1, the MPA does contemplate a situation in which there may not be coterminous, because it's
Only
until
as regards income.
that is so far as income is concerned, deals with income. But the point is that apologies, my lady.
It's a bit odd.
It's
I
a
mean,
bit
they
odd
made-
that it's
they made
only
it-
income.
Yeah, they made a specific, gone to all the trouble of making specific provision in relation to income for that scenario, and they don't extend it to the capital participation, which is a bit odd.
Well, presumably because they think they're going to get it back at par.
Well, that might be the answer.
Yes,
That might well be the answer, that if you terminate early, you get what you put in.
yes, absent default.
Yeah,
Absent default.
Absent
I mean,
default.
that may well be.
Default is a difficult situation, isn't it?
Well, it creates. It's difficult in one sense, but in a sense it's easy because you're squarely in the territory then of the capital risk being on the participant.
Yeah.
And giving meaning to that.
And also, it might bring an end to the underlying contract anyway. The default
Yes.
might actually, in practical terms, bring that to an end.
Yes, I suppose that's right as well. So clause 7 is significant because it identifies a situation which the judge says doesn't exist and which he uses as a reason for some of his analysis. There is an additional provision which is worth just quickly looking at, 13.2, variation of the participated transaction, page 19. The seller may, without the prior consent of the participant, take such action that would result in any increase in the credit amount, any extension in the date of validity, or extension of the expiry date, provided that, and you can see it doesn't affect the rights or obligations of the participation amount shall not change, and the participant shall have no liability in respect of any payment made or liability incurred after the original validity date. But then this, clause 13.3, in cases where the participant doesn't agree to any such action where its consent is required, the seller shall have the option but not the obligation to terminate the participation agreement, or, if it's funded, request elevation. 13.4, if the seller exercises its option to terminate the participation agreement, all income payments accruing up to the termination date will be payable by the seller to the participant, and any amount in respect of principal paid shall be reimbursed by the seller to the participant under this clause. So that's at par. With effect from the date on which the seller pays all amounts due, any transferred rights will automatically be retransferred and reassigned back to the seller without the need for any further action. So that's dealing with a situation where the seller has terminated the participation agreement, and it deals specifically, therefore, with the situation of the participant in that scenario, gets all the income payments it would be due, gets its money back. But that's not dealing with the situation where you have a default. It's dealing with a situation where the seller has essentially unilaterally done something, and it's therefore understandable that the parties have provided that in that situation the participant gets out without loss. But in a default scenario where the risk is eventuated, that cannot be the right answer. And 3 final points on the MPA. There's a reference at clause 15 to general debt restructuring, which is defined at page 8.
Well, before you leave 13,
Yes.
and the importance of this, isn't it, is that you could regard the provision in relation to the maturity date in the MTB participation as effectively entitling Yieldpoint to termination as per 13.4.
Yes, absent default.
Absent default.
Yes. I'm not sure that one quite gets through the gateway into it because of the because it would have to be the seller exercising its option under 13.3.1.
No, but I think more broadly, this recognises that this provides for an early termination where the participant gets their capital back.
Yes.
And given that that is recognised as something that can happen under the MPA, then it rather puts in a different light the suggestion that the parties cannot have meant that there would be a termination after 12 months,
Exactly.
given it's anticipated that there might be a termination.
In the same way that clause 7 does that, for different situations, but
different scenarios. But I think the judge is saying that given that there was this provision for an early termination, the parties can't have intended.
Yeah. Whereas in fact the MPA contemplates it.
Whereas the MPA actually anticipates that there might be a termination.
Exactly.
Did he deal with that provision in his judgment?
No, I don't think so. I'm not sure it was raised by the parties at trial. General debt restructuring clause 15, page 20. It is the intent that the participant will bear the risk of any general debt restructuring in relation to a participated transaction. General debt restructuring is defined on page 8 at the bottom as any rescheduling or reorganisation of the indebtedness of a recourse party, that's by MTV, which satisfies the following tests, and then you can see A and B. I think it's right to say that may not be the current situation, but what it does identify is a situation where the risk is very clearly allocated to the participant. And as we saw in that document I showed you earlier, we were in the situation where there was a reorganisation in progress. Yes, it's that document that we had on page 719 behind tab 39. MTV continues to be subject to a judicial reorganisation agreement entered into by MTV and its creditors, effective from the 4th of September 2020. So it may be the position that we are in the context of within the definition of a general debt restructuring. But I make a more general point, which is that this is an example of the risk falling very clearly and being allocated on the participant. That's one of the last of the 3 points I want to make. Representations, clause 19 of the MPA, page 22. 19.2, each party represents and warrants in relation to a participation agreement, represents and warrants the other, that it has made and it will all times make its own independent investigation of the financial condition, etc., of the recourse parties and any of other factors for the relevant factors for the assessment of the credit risk. And what that shows is that, again, it's consistent with the participant needing to be worried about MTV, but not needing to be worried about Kimura.
Right, why would they care about MTV if they weren't on risk?
Exactly, and the point that's made by my learned friend in relation to that is, well, they were concerned because they wanted to know, and they sought information about the position of MTV because they were concerned to know what the participation payment amount would be, because that was a significant part of it. But that doesn't really answer the representation point.
If this was an unsecured loan to Kimura, one might expect to see evidence that Kimura's own financial position was investigated.
Yes.
Was there any evidence?
There isn't any evidence of that, as far as I'm aware.
Manu, that's a point picked up in our skeleton. There was
Yes, but it's possibly a double-edged sword.
but yeah, there was extensive investigation of Kimura's financial position in the context of the parties originally entering the relationship in February. And there was ongoing monitoring of Kimura's financial position through the currency of the participation. But since no point was ever raised about that in advance, no evidence or documents were produced on it. So that's why I take the point in my skeleton. It's not open to them now on appeal to say this point is in our favour, because if you'd ever said that before, all the evidence would have been given on that point. But it is not right to say there was no interest in monitoring of research into assessment of the financial position of Kimura.
Thank you.
I'm not making an evidential point, really. What I'm really focusing on when I look at the representation provision is to suggest that it's another factor in our favour, that the focus, so far as the representation concerned, is on MTV.
It's a commercial utility that you're making. You're saying, what's the point of having a representation like this if the financial position of the underlying party has nothing to do with the participant?
I respectfully adopt that.
Yeah.
Entirely right.
Well, and the parallel point is that there's nothing in the offer of acceptance that you'd expect to see as regards the position of Kimura if it was the recipient of a loan.
No, all you have is the adoption of the MPA provisions, which include at 22.6, which is my last point on the terms of the MPA on page 25. Save as expressly set out in the participation agreement, the participation is made without recourse to the seller. The seller should not have any liability or obligation to the participant relating to the transaction or the agreement, except as specifically set out in the participation agreement. And if one asks, well, what is specifically set out in the participation agreement that creates a liability on the part of the seller, and specifically a liability to repay $5 million come what may, irrespective of whether there's a default on the 31st of March 2022. There isn't anything that does that. And therefore, this is another example of a provision that, in order for my learned friend's interpretation to work, you have to cross it out. Or you have to interpret maturity date of the participation as something that specifically imposes a liability, specifically imposes a liability on the seller. Again, it doesn't do that.
But to be fair, though, a non-recourse provision anticipates that participants will receive its monies from capital repayments by the borrower.
Yes.
Whereas it's plain, isn't it? It must be the case that the maturity provision anticipates that payment will be made by Kimura.
Yes, that's a fair point. I accept that.
So there is recourse to that extent.
Yes, and then one is back to what does that mean in practice? Is it come what may, or is it affected by default? Yes. But it is a provision that doesn't sit very easily, I would submit, with the absence in the offer and acceptance of express language identifying what is meant as to what should happen on the maturity date. I mean, the better point, I suppose, is when one looks, as we will do now, at the offer and acceptance. Let's look at that behind tab 3 of the same bundle. Under the heading offer, third paragraph, second paragraph, this is an offer as defined in the master agreement. In this offer, unless otherwise indicated, definitions from the master agreement apply. All relevant terms of the master agreement as at the date of the offer will apply to any participation agreement concluded pursuant to this offer, as if those terms were set out here in full with necessary changes. For the avoidance of doubt, the express terms of this offer will override or modify any conflicting or inconsistent terms in the master agreement, unless otherwise indicated. References to clauses and appendices are to clauses of and appendices to the master agreement. And of course, the offer starts with the fact that you're dealing with a seller and a participant at the top of the page. And then a reference, of course, then to the MPA under the heading offer and to the MTV.
Participation.
Yes. And participation is a defined term in the MPA at the very outset in the recital. So what one is looking for is something that is in the offer that conflicts or is inconsistent with something in the MPA that one can say is expressly therefore overridden, something in the MPA that's overridden or modified. And what you have is the opposite. What one has is the adoption of all of the top concepts and terms that one has in the MPA in the table that you have starting at the bottom of 37, page 37. Type of transaction, it's a participation. It's a funded participation. The recourse parties, as defined in the MPA, are just MTV. The transaction documents, which is relevant for the security side of things, are described as the facility agreement. And then at the transactional level, other agreements. Then at the top of page 38, participation amount, $5 million. That's as defined on page 9 of the MPA, 22.22% of the overall $22.5 million facility, all adopting the MPA concepts. Start date of the transaction, that's the MTV facility. Start date of the participation, that's this contract. Then the keywords, maturity date of the participation, 31st of March. Now that is a box in this table that doesn't appear in the template, which is an important point to note. If one looks at the template that's appended to the MPA, which is on page 27, 28, you can see most of these boxes are ones that are just lifted from the template, but this is clearly a modification.
That's because the template doesn't specifically cater for a shorter term participation than the overall agreement.
Exactly. Exactly.
So just looking at the word start date, maturity date, it's the beginning and the end. It could equally have said end date of the participation.
Yes, exactly. It's the start of the investment, the end of the investment.
Yeah.
And I should have said that once you look at the concept of a participation amount and a participation percentage, you then have to go back into the definitions of credit amount and those that are necessarily imported by using those terms. There isn't any suggestion in the use of those terms in this offer and acceptance that they are intended to override or modify anything in the MPA. They're just adopted in a vanilla way. The validity date of the transaction, the 31st of December, that's the end of the MTV facility. The number of days of the transaction, that's this transaction, that's the Kimura Yieldpoint sub-participation. The settlement.
Mixing up the transactions there.
Yes.
Yes, there is a mixing up. Yeah. But it's tolerably clear what's meant in my submission when one looks at the numbers involved. Settlement amount, if any, 5 million. As we saw, that's not the amount that's settled come what may at the end of the transaction. That's the amount that's paid in at the beginning from the definition on page 10 of the MPA. Then special conditions at the comments, if any. Now in the template, this is a box that appears in the template, and you can see that on page 28. And you can see that on page 28, what the parties contemplated this box might contain is more detailed information about the transaction if necessary. There isn't really any, the starting point is there's not really any suggestion that this is going to contain provisions that fundamentally alter the MPA structure. And indeed they couldn't do that because of that provision I showed you in clause 3 of the MPA, that the offer has got to be substantially in the form of the appendix.
I suppose it all hangs on what you mean by substantial.
It does, yes. But what it doesn't mean is essentially crossing out all of the provisions that I've showed you already in circumstances where, completely contrary to that, the parties have adopted those defined terms in the appendix. And what one has here are essentially something that permissively gives Yieldpoint the ability to renew and extend its participation. It would have to enter into a new offer and acceptance if it did that, and it has to give notice of its intention to renew. Now, my learned friend's case is that the significance of the inclusion of these is that they provide that Yieldpoint must notify Kimura of its intention to renew, but not of its intention to withdraw. That's for paragraph 40 of the skeleton argument. In my submission, that's not the right analysis. It simply gives them the ability to extend their participation with all the upside benefits of it by way of renewal. It doesn't say anything in my submission, one way or the other, about whether or not the amount is repayable, absent renewal and in the circumstance of a default.
Well, it's obvious that if they don't give notice, then maturity, whatever that means,
Yes.
happens.
Yes.
Certainly.
So you can't really make anything about it.
No.
The third bullet point under special conditions refers to Kimura further reducing its retention share. And
Yes. Well,
You might, well, say it begs the question, but presumably on your case, you would say that is consistent with a real reduction in exposure.
that is exactly
And
the point.
you read that with the definition of retention share.
Exactly. The parties adopt in the very condition that is said, the conditions that are said to assist my learned friend, a concept that is inconsistent with his case. It's small r, small s, but it must be retention share in the way defined in the MPA.
Just the word further that's important there.
Yes, further, because they've already sold down 5 million or 22.22% of their interest.
But then retention share is specifically defined to 3 boxes below. So
Yes, 17.5, and that's obviously the difference between 100% and 22.22% of the overall facility.
Yeah.
Or 5 million in
But
numerical.
it's a reduction of 5 million, representing, you would say, the participation they've sold down under this arrangement.
You can't interpret it in my submission any other way. Must be that must be what is meant when they adopt those concepts in the offer and acceptance. I'm going to turn to give you my submissions on the correct interpretation in a moment. Before that, I do that, just 4 points on the contractual scheme as a whole. It's the MPA is on a standard form. And the background information on the standard terms of it, just for your note, are in the supplemental bundle, volume 1, tab 12, at page 90. Perhaps we could just have a quick. This is a guidance note prepared by a firm of, I think they're US, Washington, DC based attorneys in relation to this, this form of agreement. And the only points I wish to highlight in relation to it are 6th paragraph down on page 90. It's been developed to allow for true sale, being a transfer of financial assets rather than to reflect the liability of one party to the other, as reflected in the earlier version of the same form. As such, for example, grantor is replaced by seller in the 2018 MPA. It's designed for use by members as an industry standard. Certain areas where there was optionality in the original version have been removed and restated, resolving the need for optional provisions. And then there's a summary that on the next page, which makes it clear that it is dealing with just the sort of MPA that we have in our case. There's then, second of my 4 final points on the contractual framework, some authority on what participation agreements mean in the form of that Privy Council opinion. Clark, Lloyds Bank and Clark, it's in the 3rd tab of the authorities bundle. The real point to take, I suppose, from it is that ultimately you have to look at the individual agreement itself to work out what the parties have agreed. That case really was concerned with a contract that didn't have the security regime that we have.
Well, it didn't have the sale.
It didn't have the sale, exactly. And so it was dealing with a different situation. I suppose what both my learned friend and I would probably take the same point away from it is that there isn't ultimately a standard form of these agreements or arrangements. One has to look at the terms themselves. It's a point that the learned judge made in his judgment at paragraphs 55 to 58, page 75, ultimately leading to the conclusion that in order for the parties to have departed from the terms of the MPA, there would have to be something that was I think the language he used was clear language is needed, paragraph 59. He says this at the top of page 76, given the starting point, which is the starting point that one gets from the standard concept of sub-participation, which he describes at the bottom of page 75, as involving the sharing of both risk and reward and the exposure of both capital and income stream, and he refers to retention share. And there's another reference there to the coterminous PT point, incidentally, that I showed you in paragraph 72. Paragraph 58, he makes the same point. So then at the top of page 76, paragraph 59, the learned judge has given this starting point, both generally and as contemplated by the MPA, which gave rise to the participation. Clear language is needed to alter the default structure in a significant way. The more significant the departure, the clearer and stronger the language needed. It's inherently unlikely, the judge said, that these parties intended to make a specific trade pursuant to the terms of the MPA, which didn't resemble or replicate a conventional sub-participation. Whilst unlikely this was not impossible, I'll come back to the significance of that ultimately on my points on interpretation. But the second point really is that one has the Clark decision, but it doesn't ultimately, on the facts, help us. It's simply the principle. But one has to look at it as a matter of construction. Then there's the transaction overview, which is the document that is behind tab 2 in the first volume of the supplemental bundle. This is worth having a quick look at. The judge refers to this in the judgment, and you can see that he does that on page 71 of paragraph 36. Just looking at the document itself on page 34 of the first volume of the supplemental bundle, you can see it's concerned with this pre-export financing facility.
I'm really sorry, Mr. Valentin, could you start? I was a bit behind.
Of course, no. Well, in between the MPA and the offer and acceptance in the bundle,
Yes.
so between tabs 1 and 3, there's a second tab that contains this transaction summary.
So we're talking about the tab 2.
Tab 2,
Yeah.
exactly. Yeah, exactly. And this is a document that was provided to Yieldpoint in March 2021. And the parties both accept is admissible material if one is dealing with working out what the contract means. And you can see a description of the relationship between MTV and Kimura in the first three paragraphs, and then the opportunity is described in the fourth unnumbered paragraph on page 34 as an opportunity for Yieldpoint to co-participate alongside Kimura in a working capital and pre-export finance facility to invest on a pari passu basis alongside both Kimura and Anglo-American, and then a description of what the money's for. There is a comprehensive security package backing the financing, and then on the next page, transaction highlights at the top of the page. That's a description, I would respect this most likely of the MTV transaction, but it may be of both. You can see that it's described as a margin, penultimate bullet, plus price participation extends yield projection to double digits, investment for fixed amount and fixed tenor with no cash recycling or cash drag. Then there's a description of the MTV facility, and then the risk participation transaction is described at the bottom in terms which I respectfully submit are consistent with our interpretation. There's a seller of the participation, Kimura. The participation amount is defined. I mean, you can see that the documentation, if one turns the page to page 36, documentation, the master participation agreement is the agreement they'd entered into that between them in February. So when the parties in this summary use the terms, or Kimura uses the terms, that are referable to the MPA. It must be meaning them in the same way and being understood in the same way. The tenor is a 12-month fixed term investment. That is entirely neutral as to the issue of repayment, but is in my submission consistent with our interpretation that it is.
The investment isn't a loan. A loan is a loan. Investment means you've got skin in the game.
Quite, my lady. Form of participation, consistently with that, committed participation, funding on a pari passu basis. You can then see the income elements of it, and you can see that there's a reference to the copper price related participation payment that's due. And then ranking, top of page 36, senior secured pari passu with Kimura, reflecting the provisions that are in the clauses 5.4 to 5.6 of the MPA, and then a reference to the MPA itself. And then finally, it's a point that is easy to miss, but if you look at the very bottom of the page, on each page, it says in the bottom right-hand corner, returns are not guaranteed and capital at risk. Now, well, the learned judge interpreted that as just income. And he did that at the end of the judgment. Paragraph 91. So far as page 82 of the core bundle, so far as may be relevant in the spirit of the postscript, this position, in other words, that it's income only, is consistent with the warning language in small font on the transaction overview, which he then refers back to. But it isn't consistent with that because it says capital at risk. And that means can only mean what we say it means.
Well, in the sense that, doesn't this document rather encapsulate the issue, which is that everything about it appears to recognise a participation with capital at risk, except for the words 12-month fixed-term investment.
Yes, which then gets you asked, well, what does that mean in practice? What does maturity date of the participation mean? Why, I suppose, more fundamentally, did the parties choose to do it for 12 months rather than any longer? And that's the fourth point I was going to make just on the agreements themselves. There are some indications or clues in the papers as to why it was to be 12 months only. If one just goes to the second supplemental bundle, at tab 21.
You mean the second?
I mean supplemental bundle volume 2. One of two.
One of
Volume 2. Apologies again for the
volume 2.
numerical. Tab 21. This is March the 30th. The day before, no, the day of the offer and acceptance being executed. And
Sorry, give me the tab again, please.
it's tab 21. And what you should have there is an email that's dated the 30th of March, 2021.
Yes.
And you can see, I'm looking at the one that's got the red text towards the bottom of the page. And this is Kimura writing to MTV. I'm going to show you an MTV Kimura a Yieldpoint Kimura document secondly in a moment. But this is what Kimura is saying to MTV on the day the contract is entered into. Subsequent to our recent calls and discussions around the Kimura participation, that's Kimura's participation in the MTV facility, and our intention to move the facility to long-term committed capital funding, we've made some positive headway and have the following to update. We've agreed to a sub-participation with another investor who is matching the existing Kimura 12-month liquidity for up to $5 million, where there's no change to Kimura as the lender of record. This move is the precursor to move the entire facility to a long-term funds once the facility builds a track record. We expect the $5 million to be received this week. As above, Kimura will be remaining as lender of record, and the participations are sub-participations under Kimura. And if one then looks on to sorry, goes back to the 26th of March 2021, tab 20, page 624. You can see Kimura communicating with Yieldpoint on the 26th of March. And this is about the question of whether MTV has to consent to the sub-participation. 2/3 of the way down the page. In any case, we'll inform the borrower and get their acknowledgement on Monday. We've spoken to them recently about our intent to partially sell down via risk participation a portion of the loan whilst we line this deal up for the long-term vehicle. Well, of course, that's obviously consistent with it being a sell down and a participation, leaving aside questions of admissibility at the moment. But the point about the 12 months and matching our 12-month liquidity seems to marry up with the way the facility itself is structured with MTV, where Kimura ultimately had the right to, if its investors wished it to pay them back, to give notice to MTV that it wanted out of the facility and that it could issue a notice. And that notice you see at clause 25.11 of the facility agreement with MTV. It's supplemental bundle 1, tab 13, page 245.
Someone split it between two bundles.
Yes, and it's in the second of the two volumes. 245.
2511, did you say?
2511. If prior to the expiry of the facility period, Kimura receives a notice of redemption from any of its limited partners, Kimura may issue a notice to the borrower demanding repayment of its participation by a date that is no earlier than 12 months after the date of the repayment notice. And then page 246, I don't think it matters for present purposes, but it identifies what then happens. Anglo-American have the first option to buy them out,
Okay.
and so on.
I may have not followed this. I thought that what the correspondence we've just been shown was talking about was putting the facility in a long-term fund rather than the paying out.
It's both points, actually. The first point is the 12-month liquidity. Why are Kimura saying we have a similar 12-month liquidity?
Oh, I see.
And the answer is because they can get out within 12 months,
Yes.
2511. The long-term fund transfer point is actually dealt with on the same page
I
at the
saw
top,
that.
2510. And that's the longer-term concept. I don't think that ultimately eventuated. But
it might be. I thought you misunderstood. I thought you were suggesting that the long-term fund point might be a reason why you'd want to sub-participate for a limited period.
It might be, but the better point, perhaps the stronger point, is the 2511 point, I think. But I think they probably both point in the same direction. And that's why you see them in that email referring to that.
I'm getting a little confused now, though, about your approach to parole evidence.
Well, I'm not saying this is relevant on interpretation. I'm not saying that at all. I'm giving your.
If it's not,
Why am I
what we're
mentioning
doing,
it?
it's
Why
what
am I
we're
mentioning
doing,
it?
isn't it?
Yeah, only if you're curious as to why they would be dealing with a 12-month facility.
Well,
But you may not
that
be.
may be subtle advocacy.
Let me turn then to the interpretation of the participation itself, and we've covered a lot of these points. We've covered some of these points already. We say that the correct interpretation of the words maturity date of the participation cannot be that Kimura had agreed to repay the $5 million US on the 31st of March, irrespective of default. And we make 6 points in support of that proposition. The first is that because the correct starting point is that the offer incorporated the MPA provisions, unless expressly doing otherwise, the correct interpretation must be the one that gives effect to all of the terms of the MPA that are consistent, only with this being a sub-participation arrangement. So we rely on all of the points that I've shown you, which expressly appear in the offer and acceptance, which refer back to definitions and concepts in the MPA. There is the language of participation throughout the offer and acceptance. There's the use of the defined terms. And then there's just more specifically the fact that you're dealing with a participation amount of 22.5% of the participation percentage and all of those points, which take you back into transferred rights, retention share, credit amount, and related recourse rights. So that's the first point. Second point is that Yieldpoint could only escape from these points if it could show that the express terms of the offer are in conflict with or are inconsistent with the terms in the MPA. But they can't do that because there is no such conflict or inconsistency.
Well, potentially 13.4 is quite important there, isn't it?
Yes. Yes, the ability to terminate.
The parties have agreed a termination, which might otherwise have arisen under 13.4.
Exactly. Yes. The point we canvass each other earlier. Apart from the words maturity, the box that contains maturity date of the transaction, all of the other boxes in the table are ones that you find in the appendix. All of the boxes that matter for present purposes are the ones that you find in the appendix.
Sorry, I've got your 6 points. Are we still on point 1?
We're on the second point.
So are we on 3?
They were on 2 actually. The first point was that you've got to adopt an interpretation, I respectfully submit, that gives effect to all of the terms of the MPA.
In subpoint, yeah.
And so 2 was only escape of conflict.
Exactly.
Yeah.
Exactly.
And so this is part of that.
Part of that. And part of that is there isn't any conflict or inconsistency.
All the boxes are in the standard form except for the one that we
All boxes are the same except for,
maturity data transaction.
yeah, except for 1.
And the offer itself states, unless otherwise indicated, all relevant terms of the MPA will apply as if those terms were set out here in full with the necessary changes. Page 37.
So the words maturity date of participation, using the word participation means it's not a participation. That's the gist of it, yeah.
Yes, it's not a defined term in the MPA, of course, nor is it a term of art, maturity date of the participation, but the fact that they use the words of the participation rather than of alone is a pointer. And again, none of the provisions in the MPA that I've shown you are consistent with this being, these words meaning it's a loan only, not a participation. Nor, if one takes the judge's test, just the last point to make as my second submission, are the isolated reference to maturity date of the participation, as he puts it, sufficiently clear language to create a hybrid form of sub-participation. The passage I showed you from paragraph 68 of the judgment. That's the second point. The third point on interpretation says that if it's right that the various terms in the MPA are not modified or overridden, then Yieldpoint's interpretation would make large parts of the MPA and even the offer itself redundant or otiose, contrary to the well-established principle that that isn't the right, usually it's not the right interpretation of a contract. And we've cited, it's paragraph 17.1 of our skeleton argument, among other cases, Secretary of State for Defence and Turner, which makes that point. Now, the learned judge acknowledged in the judgment, paragraph 63, that Yieldpoint's hybrid analysis renders material parts of the MPA otiose. So he acknowledged that that was the effect of their interpretation, but still accepted it. But I suppose more simplistically, one could say that it really makes a nonsense of the parties' use of Appendix 1. Because if they're using Appendix 1 as the basis for their contract, it would be surprising if in doing that, they were also intending not to use any of the defined terms in the way they appear in the MPA.
Sorry, by Appendix 1, do you mean the MPA or?
I do. I mean the appendix to the MPA, which is the template.
Oh, I see what you mean.
Yeah, the document that appears on page.
Using the form of offering.
Exactly. Yeah.
Why use that if the intention of the parties is simply, you give me $5 million, we'll give you $5 million back with a nice rate of interest at the end of it.
Exactly.
They could have produced a template that said that on one side of A4 without referring to the MPA at all.
Exactly. The fourth point is that Yieldpoint's interpretation really assumes what it seeks to establish. If the starting point is that the words maturity date of the participation can only mean the loan, then I suppose it's just about possible to see why it's then necessary to seek to reverse engineer everything else in the MPA and the offer and acceptance in a way that aligns with that. And that indeed is my learned friend's approach. If you look at his skeleton argument at paragraph 28, which is in the core bundle, tab 3, page 53. And it's so important, it's described as a crucial point that's underlined. It's important to note that if Yieldpoint is to be paid at the end of the period, such a payout cannot be contingent on payment by MTV, but must on either interpretation be contingent on Kimura. But the if Yieldpoint is to be paid at the end of the period begs the question.
Well, it's back to the reference to the pre-contractual discussions. You'll get paid at the end of 12 months.
It is, exactly. It's where I said to my lady and my lord earlier that the judge goes wrong too in paragraph 77 of the judgment. If, though, the words maturity date of the participation are treated without preconception as neutral, which is the right starting place for an interpretation exercise, then the correct interpretation of them is the one that gives effect to and fits within the overall contractual scheme of the MPA. And of course, that's the right approach. See, for example, Sigma Finance. It's tab 6 of the authorities bundle, Lord Mance at page 101. An individual clause, as Lewison puts it in his most recent edition of his book, takes its meaning from the context of the document in which it is found.
Right, so your starting point neutrally is that the word is participation. So you find out what a participation is by looking back at the MPA, and then you say, well, how do you apply the concept of a maturity date to that?
Yes, exactly.
In context. And you've got a start date, which is when you put the money in, and a maturity date, presumably when you get the money out.
Exactly. That's the fourth point. The fifth point is, if one looked at it from an alternative perspective of implied terms, which arise essentially at the same result, is Yieldpoint's interpretation necessarily involves implying an obligation to repay on the 31st of March, irrespective of whether MTV is in default. There is no such express repayment term anywhere in the MPA or the offer, as the judge recorded in his judgment at paragraph 64. Indeed, as I showed you in paragraph 21 on page 69, the learned judge held that the corollary of the structure created by the MPA was that there was no independent obligation on the seller to repay any principal amount. It was pay as may be paid and non-recourse. But on obviously well-established principles, you don't imply a term unless it's necessary and obvious. And in addition, it wouldn't contradict the express terms of the contract. And in my submission, an implied repayment obligation isn't necessary or obvious, given the parties were contracting on the basis of the MPA. And it would contradict the overall contractual scheme.
Forgive me, this is where I get slightly lost, because I thought that you were accepting that if there is no default, there is an obligation to repay.
Well, the obligation in that situation is that the participation has come to an end.
But that is not pay as paid, is it?
It isn't in that situation.
No.
No.
So there is undoubtedly here, whether it's express or whether you have to imply it, there is an obligation on Kimura to repay if there's no default.
If there's no default.
That's you accept that.
I do accept
So there is an obligation to repay.
Yes, and how it would work in practice is that it would have to be refinanced. So you either get someone else to come in and participate and pay it back that way, but
That'd
ultimately
be a matter for you.
it would. It's a matter for us, yeah.
I mean, you may have had that money sitting in a bank account somewhere,
Exactly. In that situation,
not
absolutely
not earning LIBOR plus 7.5%.
probably not. No, indeed. No, that's quite right. I do accept that. We're dealing with the situation of default and what happens in that situation. If the default
You see,
has happened. In that
I mean, that's the sort of the tin opener going into the tin, isn't it? As far as Mr. Pilbara is concerned. Yes, he gestures with agreement, surprisingly. And he says that once you've got that, you have to then look at, well, what does that mean in the context of all these provisions? And we've been through it all. I'm not saying it changes the analysis, but I don't think one can say here there's no implied obligation to repay.
I accept that in those circumstances. The real question is there an implied obligation to repay $5 million in circumstances where the risk has eventuated, the default has occurred? And in my submission, to imply a term in those circumstances to that effect would necessarily involve a contradiction with all of the provisions in the MPA that involve the capital being at risk. The last of the 6 points is a point about commerciality. In our submission, it's only our interpretation that really makes any commercial sense. The parties entered into an umbrella agreement for individual participations. Why borrow money from Yieldpoint using that framework when it's plainly concerned with something completely different? And that's where the judge's inherently unlikely observation at paragraph 59 comes in. But he doesn't really follow through in my submission on that in the rest of his analysis. The commercial terms offered by Yieldpoint offered by Kimura to Yieldpoint involved, as we've seen, very substantial income payments for what was in effect just a $5 million loan on the Yieldpoint case. The learned judge really dismissed these arguments in his judgment at paragraphs 83 to 86, and engaged in what I would submit really was speculation as to there may have been other reasons why it was perfectly sensible for Kimura to have borrowed $5 million.
The commercial effect of what is suggested is that obviously subject to the credit worthiness of MTV, Kimura was agreeing to pay these sums to Yieldpoint for its loan.
Yes.
It is borrowing $5 million and paying out of its share LIBOR plus 7.5 and the profits it would have received.
Yes, it gets that money from.
It gets that money from MTV, but
doesn't keep it.
But it is paying it to Yieldpoint, not because Yieldpoint is investing its capital, but because it has made a loan, and so the question for Kimura is what's the commerciality for that? I mean, I suspect that they could have got a rather better commercial deal from a bank.
Well, LIBOR was below 1% at this point.
Yeah, it's very difficult to understand how it made commercial sense to borrow $5 million at those rates. And Mr. Pilbara will be able to come back on this, don't worry. But that seems to me the commerciality of it seems very strange. That you would give up your high return on $5 million worth of your loan simply because somebody else had lent you that money.
That's the 6th point.
It's almost the sort of rate that you would pay to a lender of last recourse if you couldn't get a deal with a bank. If you're talking about a 10% yield
Yes.
against the market conditions that we all knew prevailed at the time.
But as we know, it was fully funded already, so it's not as if the money was needed to give to.
But we don't know what
We don't know.
we don't know what their
What they did with
funding position, do we?
Well, we do know that the facility with MTV was fully funded.
Yes.
No, but we don't know how they funded it
No, I accept that.
or what other funding needs they had.
There wasn't evidence about
No.
that. I accept that.
One point that forgive me, there's the converse, just to be clear, of your points about what is in the offer and acceptance. Do you not also make the point, it's rather important, what isn't there? Because if this is a loan to Kimura, why is there none of the template, why is there none of the boilerplating you'd expect in relation to a loan to a Cayman Island company?
Yes.
I mean, there's
Thought of
absolutely
that. That's a good
nothing
point.
here about default by Kimura.
No, quite.
I mean, Kimura could go bust on day one. There's nothing accelerating the loan in those circumstances.
No, and this is why I make the point about there being no recourse to the seller.
Yeah.
A general point. You don't see. You could say that's a limited concept, but it is reflective of the fact that there isn't the machinery that one would expect to find to enable Yieldpoint to enforce. Its security comes from MTV via the clause 5.4 mechanism. Or on our case. There were 2 other things I wanted to do, and I'm obviously keen to make sure I give my learned friend the opportunity for him to just finish off on these points. The first is just to make a couple of points about the judgment itself, some of which I've touched on already, and then the second is to deal with the fair market value point, which is obviously an important point my learned friend makes. So far as the judgment itself is concerned, I've shown you where, in my submission, the judge goes wrong in his analysis, where he says that there are difficulties, they're surmountable, and they have to be surmounted because this was always proposed as a fixed-term loan, paragraph 67 to 70. And there are, in my submission, when one steps back from that, really 3 core errors in that approach from the learned judge. The first is that he assumed, in my submission, incorrectly, that fixed-term deal meant necessarily that the parties agreed that Kimura would repay Yieldpoint even in circumstances where there was default. And that, in my submission, is to read into the words maturity date of the participation, a concept that was simply never there. That's the first point. The second is that in making that assumption, the judge really failed to perform the process of iterative interpretation that was required. In my submission, what should have occurred was to read the words on which my learned friend's case depended, maturity date of the participation in the context of the contract, point I've made already, and approach that process neutrally. Instead, he assumed, the learned judge, that this is a loan repayable on the 31st of March, and then sought to read all the other provisions of the MPA and the offer, indeed, to fit with that assumption. And I've indicated that that was not the right approach. And when one looks at the way the learned judge approaches, just a couple of examples, things like retention share, which we've looked at the definition of as the percentage of the credit amount of the participated transaction retained by the seller at its own risk. That's expressly adopted in the offer, as we saw, as $17.5 million US. Cannot therefore be said that the offer modified or overrode that concept because it expressly adopted it. My submission, the only possible interpretation of that is that Kimura had not retained $5 million of the amount at its own risk because it had sold that amount to Yieldpoint, and that was therefore then at Yieldpoint's own risk. The judge held correctly, paragraph 58, that this definition, the definition of retention share, presupposes some allocation of capital risk to the participant. And he then indeed went on to hold that that definition therefore is a problem for Yieldpoint's analysis, paragraph 65. But the way that he then dealt with it at paragraph 68, page 77, doesn't answer the problem in my submission. Because there isn't any basis for confining the concept of retention share to income payments. There's just no basis for that in either the offer or the MPA. So that's one example. Another example is participation percentage, which is defined, as we saw, as the proportion that the participation amount bears to the credit amount. That was again expressly adopted in the offer, page 38. The only possible interpretation is that Yieldpoint was participating in the principal risk, not simply in relation to income payments. And that's why the definition talks about the offer records 22.22% of the overall USD 22.5 million facility. Yieldpoint had assumed the default risk of the $5 million. And the judge didn't address that problem in his judgment at all. And there, I won't, in the time provided, make the points I was going to make in relation to the security regime, but there's the same difficulties ultimately. If you end up with a situation where the only way it works is if it's income only, that is, in my submission, an impossible interpretation of the security provisions in their own right, but having regard also to how it would work in the context of the facility, the MTV facility, and in the circumstances where there was, for example, elevation or Kimura was insolvent and Yieldpoint was seeking to enforce those rights, as it would no doubt wish to do, pursuant to the machinery that's in the facility itself. Now, the third aspect of the judge's approach, which I must touch on briefly, is his reliance on pre-contractual discussions, negotiations, and subjective expectations. There isn't, between my learned friend and I think, any dispute as to the law. There are really 3 points. The exclusionary rule in Chartbrook excludes evidence of what was said or done during the course of negotiating the agreement for the purpose of drawing inferences about what the contract meant. We're all very familiar, I'm sure, with Lord Hoffman's paragraph 42 to that effect. It's Authorities Bundle, tab 5, page 73. The second point is that there is a limited exception with the factual background known to the parties at or before the contract, including as to the genesis or objectively the aim of the transaction. It's the point that my learned friend takes by reference to Pren and Simmons, Lord Wilberforce, tab 2 of the Authorities Bundle. It's page 1385H of his judgment. And then the third point is that subjective evidence of any party's intentions is to be disregarded. For example, Arnold and Britton, Lord Newberger, paragraph 15, tab 8 of the Authorities Bundle, page 136. Now, in our case, the exclusionary rule in relation to pre-contractual discussions and negotiations is reinforced because we have a widely drafted entire agreement clause, which I didn't show you. It's in the MPA, clause 22.3, page 24. It deals in particular with pre-contractual communications, which it provides are superseded by each participation agreement. That necessarily includes the parties' discussions during the course of negotiation of this participation. Now, when one looks at the judgment, it is in my submission replete with references to the judge looking at and taking into account what the parties discussed before entering into the contract. I think I showed you some of these references earlier, but just for a more complete list. Paragraph 30 to 32, you can see that on page 70 of the core budget, you can see that there's reference to what Mr. Polacek recalls by way of discussion in paragraph 30. There's then a reference to not cross-examining Mr. Polachek in relation to that, and Mr. Polachek clarifying his evidence that things were said at the 18th of March meeting, that Kimura would pay back the $5 million at the end date or at the end of our deal, or equivalent words, and that he was then given an assurance about it being paid back on the 31st of March. See paragraph 38 below. I should just say that in relation to not cross-examining, the answer to that is that ultimately, if this material is inadmissible, you don't need to cross-examine on it. And this was a shorter trial scheme case where the rules make clear that you only have to put your main points to a witness. So there wasn't any need to cross-examine on that or any consequence from not doing it.
What was here? The participation agreement, as you would expect, is assignable. So in those circumstances, interpreting it according to discussions between the parties prior to the master agreement is hopeless.
Yes, that's
I mean, a purchaser of the participation interest has to be able to look at the documents.
yes, yes, I agree, accept that. Grateful, my lord. A couple of other references. Paragraphs 37 to 38, we looked at this already, the reference to the first offer, and being satisfied that both documents, both that and the transaction overview, are admissible, and no problem with that in relation to the transaction overview, but so far as looking at the pre-contractual drafts are concerned, not appropriate in my submission. And you can see that there's then a reference to manual adaptations, paragraph B. The changes themselves may matter when seeking to ascertain the party's common objective intention as enshrined in the executed specific terms. Well, this wasn't a rectification case, so that isn't an appropriate course to take in my submission. And you can see at the bottom then more references in paragraph 38 to exchanges by email before the contract was entered into, and so on. And then the key bit really is when one gets to 70 to 72 of the judgment, the pivot from all the difficulties to having to surmount the difficulties because this was always proposed as a fixed term deal. And then a reference to, you can see in paragraph 70, Mr. Polachek's unscathed account. The special conditions and their rationale, as I articulated an hour before signing, corroborate his unscathed account of what Kimura had told him, to the effect that Kimura would pay us back on the 31st of March. I find as a fact that that's what Yieldpoint was told. Yieldpoint was assured it would get its capital back after 1 year, entirely neutral as to what happens in the default scenario. But you can see that when one gets then to paragraph 72, and really the fundamental conclusion as to what the words mean, it's a conclusion that's made in this immediate context. In other words, the context of what had been talked about back and forth in my submission inadmissibly, as set out in all those previous paragraphs. And you can see that, for good measure, you can see at paragraph 77 on page 79, in the context of a loan, repayable loan, and the point from Chitty, so far as relevant, this reflects the discussion of what would occur upon maturity. Well, it's not relevant because it's not admissible, that as an aid to interpretation.
If you're intending to finish at 1 o'clock,
I am intending.
you need to deal with the
I'm going to turn to that
valuation
next.
It's important.
Finally, absolutely.
Um,
Absolutely. Let me make just one last point then in relation to the judgment itself. If one is looking ultimately for objective evidence of the genesis or aim of the transaction, what one has are the transaction overview at tab 2, which talks about it being an investment, not a loan, and the words used about investing alongside, and then the words at the bottom, capital at risk. And then, of course, you have objectively the evidence that the income payments are only consistent with an arrangement that involves capital being at risk. Now, that then brings me to the fair market value point. Kimura's case at trial was simply this, that Yieldpoint's investment, like any other investment, had a market value which was necessarily referable to, among other factors, whether MTV was in default or not. It was a fixed term investment, not a fixed value investment. And if the correct interpretation of its investment is that its capital was at risk of default, then the value of that capital investment in the event that a default occurred could not have been $5 million. It was the value ultimately that a market participant was prepared to pay for it at that relevant point in time.
What if a default was imminent but hadn't occurred?
Well, in that situation, a market participant seeking to acquire the loan by assignment would take that into account.
But what was Yieldpoint entitled to be paid by Kimura?
On the 31st of March.
If there hadn't been default but it was imminent.
5 million, because that was the arrangement.
Right.
That was the deal.
Because there was no default.
There was no default. The point was, is there a default in the risk period? If you get to the 31st of March and there isn't a default, obviously not the situation. In that situation, the participation comes to an end.
So the risk is
The risk shifts
the risk
back
is a
to-
default, not risk to your capital investment.
I'm not sure there's a difference between the two in this situation, but I'm sure I'm missing
Well,
something.
because the borrower may be in extreme difficulty, but by virtue of forbearance or otherwise, there hasn't actually been a default. If anyone in the market would say, "I'm not touching that with a barge pole,"
Yes.
at which point, what is the risk that you have? What is the risk that you're taking as a participant? Did you get your 5 million back, even though the market wouldn't have valued your participation at 5 million?
Well, I think it must be right that you do, because the concept is you are taking the risk for
Well,
a year.
is that right? I mean, you're taking the. Yes, if this had matured on the 23rd of March rather than the 31st, and the company had limped on making the interest payments. If your case is that Yieldpoint is at risk for a year, it is rather odd to say the fortuitous fact that its maturity date precedes the date of a formal default makes all the difference.
This isn't a credit default swap or something like that, is
No,
it?
it's not.
I mean, this is a participation where you suffer the slings and arrows
Yes.
of the lender. And the odd thing about this is they're being repaid. You seem to be accepting they'll be repaid at par if there hasn't been a formal default, even though the value of the loan may have plummeted to next to zero.
Well, you have to. The reason I say that is because you have to give effect to the fact that you've got a limited participant. You're getting income payments during the period of the year
Yeah.
as compensation for putting your capital at risk. That's the quid pro quo. When the participation ends and isn't renewed, you no longer, as participant, get your income payments because that has come to an end.
Yeah.
And the question then is, do you get all your money back, or do you have to wait and see? And I suppose you could, either alternative is possible. In a sense, it doesn't matter ultimately for the interpretation of.
But as you said, the standard sub-participation model would be paid as paid.
Mhm.
So you'll get paid via the repayments to Kimura by MTV,
Yes.
and no other way. So this is different. Kimura is paying you even though it's not been paid by MTV. So how much does it pay you? Does it have to pay you 5 million, even though it's never going to get 5 million back? Because we all know that MTV has stopped trading and is
Yes.
another creditor's impatience away from being bankrupt.
I mean, there are two alternatives in that situation. One alternative is you get to that point, there hasn't been a default, you get all of your money back. That's one possible interpretation.
Yeah.
The other interpretation, which is in a sense is more consistent with clause 8 and clause 7 of the MPA,
Value it come what may.
The difficulty with that is to what extent does your risk come to an end?
Yeah, but forgive me, and we're coming to this right at the end. My understanding, this was the issue that caused the judge to
Yes.
switch, to turn on you and say, despite everything that Mr. Valentin has said for the last 2.5 hours, I just don't see how this can work as a sub-participation agreement, because there is no obvious way of calculating that we've seen in this documentation.
Can I address that?
How
point
much is
then?
paid back?
Absolutely. Can I just address that point then directly? In my submission, you're then there are really 4 possibilities at this point in the way this works. The first is that, and the first 3 deal with the situation which hasn't arisen here. The 4th deals with the one that has.
Yeah.
The first is that it's quite possible that upon the maturity date of the participation, Yieldpoint will have renewed its participation, entered into another offer acceptance, another participation agreement. And in that event, the issue of fair market value doesn't arise because you end up with repayment under clause 8.
Yeah.
So you don't need a fair market value mechanism in either document to deal with that first situation. The second situation is that Yieldpoint might have renewed, but then sold its rights by assignment to a third party. And of course, as your lordship and my ladies know, the clause 17.2 of the MPA allows for that. Reasonable consent not to be unreasonably withheld, delayed. But the financial terms of that transaction, in other words, the assignment by Yieldpoint of its renewed participation to a third party, you wouldn't expect to find dealt with in the MPA or the MTV transaction. That's between Yieldpoint and a third party, or indeed it could have, I suppose, renewed and then agreed a deal with Kimura to pay to get out of the transaction. It'd be a slightly odd situation, but more likely renewed and then sold to a third party. Again, not in a default scenario. You wouldn't need a fair market value mechanism for that. The third situation is Yieldpoint doesn't renew. This is the point that my lord was putting to me, and MTV had not defaulted. Well, the participation has come to an end on the 31st of March, 2022, and there has to be some significance to that event in terms of the risk that arises in that situation. It's agreed that the risk is on Yieldpoint for a year. It must follow that if you get to the end of the year, the risk is no longer on Yieldpoint.
Yes, but the question is whether the risk has eventuated in. A question is whether the risk has really eventuated prior to the formal default. And I mean, it isn't, your case doesn't turn on this in the sense that you've got a default scenario, but it's equally, isn't it, arguable that in that situation, a proper understanding of Yieldpoint being at risk for 12 months means that it does have skin in the game if it's obvious that it's apparent that the underlying borrower has ceased trading.
Yes, and then it's a question of, well, what did the parties agree by, and include, what do the words maturity date of the participation mean in this context? Because that's the ultimate question. And the answer is, in my submission, that in that situation, if there hadn't been a default, even if a default was around the corner, the most obvious answer is that Yieldpoint gets back its 5 million because it's no longer at risk at that point. That's the most obvious answer to the question. It had been at risk for 12 months.
So Kimura would be foolish to have not matured any default if they could. Giving a forbearance would have been foolish.
I suppose it would create an incentive not to do that, other than, of course, there is a counter incentive, which is that it's only $5 million of the amount that is at risk, and therefore, or has been participated. So ultimately, one would expect in that situation, a rational commercial party would take the steps it considers appropriate, having regard to its $17.5 million risk as against MTV. And if it's right to accelerate or call a default. But in a sense, whether there's a default or not isn't an objective question.
Yeah.
Have they or have they not made a payment? That's not within Kimura's control.
Yeah.
But in that third scenario, no renewal, no default, the most obvious answer to the question what happens on the 31st of March is that Yieldpoint gets its money back because it had only bargained, the parties had only bargained for it being on risk in that period, up to the 31st of March.
Well, yes, but it's been on risk for a year, and during that time, the risk has eventuated to some extent, which is your capital investment has depreciated in value.
What would be the position if there was exactly teeing up of the two transactions, and you have the same scenario? So you've got a proper sub-participation agreement. Yieldpoint's got skin in the game for 5 million, but it's actually for the whole period. And you then have MTV is on the skids but hasn't actually defaulted. What then happens?
At the end of
At the end of the underlying transaction period, do they get 5 million back, or do they get a market value?
Well, in that situation, the Clause 8 pass-through payments, well, the repayment provisions would have applied under the MTV facility. They would have got the money back that they would have got, or they wouldn't have gotten any money back in that period. And then
Right.
It's entirely dependent on recoveries from MTV.
It is.
So it's
It is.
entirely dependent.
it is, and that identifies, I suppose, the alternative interpretation of what happens, no default, no renewal, which is you have to value it in that situation.
That's what I was thinking, because if what you're doing is sort of shrinking a period of participation, but you're trying to mirror
Yes,
the scenario
yes,
as if the two did tally up, and you've got it in a sort of microscopic position.
exactly.
You see, this is where the tin opener's gone in and the beans are starting to come out, because once you get to a stage where you're accepting that they get back payment which isn't related to the value of the capital presently invested, at that stage it is starting to look more like a loan. That's the difficulty with it, and that's why the judge came to the conclusion that actually the only way this could work was by saying, well, no, forget all participation, they get their money back.
Yes, but then you run straight into the difficulties that are with that approach, and that's where one has. So I suppose on this third scenario, no renewal, no default, there are two alternatives. One, you get everything back, or you get what they agree to
Either
give
get
you
par,
back.
or you get a discount based on market value.
Exactly, and
And
the argument for less than par in that situation is, if you look at the MPA, it only gives you a right to repayment when it's pay when paid, and since therefore Kimura hasn't received anything, it doesn't have any obligation to pass anything on. That's the alternative arrangement, in which case Yieldpoint has to wait for a recovery from MTV or from its liquidator, which then would then be passed on through Clause 8. Now, the difficulty with that is more consistent in a sense with it's difficult to reconcile that interpretation with capital being at risk, but for a limited period, which the parties agreed it was. In order to give some meaning to the words maturity date of the participation, it could just be the end of the participation, and then it leaves at large what happens, or to avoid the need for evaluation, you have to hand everything back. In a sense, it doesn't matter in terms of what happens in our situation, because it's clear that where there has been a default, the fourth scenario, Yieldpoint then is in a position where it has a choice. It's taken the risk the risk has eventuated in the year period, it can sit tight and wait for capital repayments to come through MTV via Clause 8 and from its liquidator. Or it can seek to sell its rights to Kimura or to a third party in circumstances where it knows that if it doesn't do that and get something back, it's at the whim of whether there's anything coming out of the liquidation. And it's in that situation that you then have to have Yieldpoint has to reach an agreement ultimately to get it out of the bind that it is in that situation, the risk having taken, it having eventuated. It can seek to sell its rights to Kimura or reach an agreement with them.
The way you're putting it as there being no obligation on Kimura other than possibly to reach an agreement if it is able to and wishes to, let's say no obligation on Kimura in the event there's been a default, rather than, for example, an obligation to pay whatever the market value is.
Well, it's in a sense, it's either of those things. It's either pay what the market value of them is, or pay when paid the amounts that come through from the liquidation or from the borrower, it being in
We still want
default.
to see what the meaning of the maturity date is then. Because they would effectively continue to be participants, waiting to get their share.
Well, they're not.
In fact, if they cease to be participants, they're probably not entitled to their share.
Well, it's giving meaning to the fact that you've put your capital at risk for a year, and if the risk eventuates, there must be a consequence from that.
Because I think, slightly unfortunately, we've reached, I think, what is rather the crucial point in the case, at rather a belated moment. I think we'll rise now.
Of course,
If you want to think,
I'll come back to
saying
you
more
briefly after lunch.
at we'll say 2 o'clock.
Yes.
Then do. But I think we'd appreciate it from the judge's judgment, and I think Yieldpoint's arguments that this really is the core of it. And if you have difficulty with what happens, it does give weight to the counter argument.
It requires a solution to be found that isn't at odds with what the parties.
Because we need a commercially workable
Yeah.
construction. Thank you. So 2 o'clock.
Very great.
All right.